Your conference. Mute on.
The law. You'll let us know, I'm sure, if you can't hear me or if you don't like me. Feel free to send in comments. I'm sure you all know how this works. I can look down at the bottom of the screen and see them. If you've got questions, please ask them. If you like what you see, please tell us. If you don't like what you see, please tell us you like it anyway. So we're here today to talk about hiring and firing. And what I'm going to say to you relates basically, or most simply put, to employees and employers. It does not deal with what we would call in the travel business the independent contractor or the outside agent. We could deal with that, though, if you have some questions. What I'll do is I'll go through my comments, and feel free to pose your questions. You may have to pose them 3 or 4 times because I'm not used to looking down here at the bottom of this screen. I'm used to seeing people in the audience and asking me questions. So if you've got one, type away, and we will deal with it as best we can. So then, let me say this first. What I'm going to say today relates basically to both employers and employees, by which I mean it's going to be useful for both employees and employers to have these things taken care of. I have dealing with people and assisting people and counseling people because they didn't have a contract. They didn't get clear on what it was they were doing with each other when they entered into the agreement, and as a result, when they have a dispute and they have a disagreement, they now don't have a particular spot to go to in order to see who it is or what it is supposed to happen. So, have that contract. Have that contract because it will make it easy during the relationship. Have that contract because it will make it easy when the relationship is over for you to know what it is you have to do versus what the other person has to do. A lot of cases, or a lot of times, I will see people put together these offer letters. Sorry, I'm playing with the camera there. I see people put together offer letters and simply say, if you want this, sign at the bottom. That's okay, as long as that offer letter is not just, hello, Harry, would you like to come work for us? But it's got lots more in it, and it covers what I'm going to go over when it comes to hiring, should in fact be in the contract, or at least in this letter. Personally, I think the letter is a better idea, the contract is a better idea, and not terribly difficult to put together if you're going to take the time to put these items in the letter anyway. So, let's go through a list of points, and I will First of all, what are you going to put in these basics that I say have to be in the contract? You're going to put in a description of what the job is, and that may be easy. If it's a travel agent, you'd say, well, everybody knows what they're going to do. But we've also dealt with cases where not everybody knows, and that particular agent may have some other duties or some other things that he or she is supposed to do, and you want them to be in the contract, because that way there's no arguments down the road, and everybody knows what they're getting into. Include in your job description, along with the tasks, what the timing of this is. If it's 9 to 5, then say 9 to 5. If it's 8 to 4, say 8 to 4. If it's going to require every other weekend or every other Saturday, Thursday nights, put it in there. Let's be clear so that when the person signs up to say, yes, I'd like this job, that they know what they're getting. Excuse me. Don't just say in it, for example, we'll have to travel with job. What does that mean? Give some details. If there's expected attendance at conferences, say attendance at conferences. Is that coming through? Yeah. And if, for another example, there is an expectation or an understanding that your employer if you're in a smaller town where basically everybody comes and goes from home and it takes somewhere between 15 and 20 minutes to get to the office. But if you're in Mississauga and you decide to move to the other side of the city or downtown or any other large city that isn't easily accessible, you could be making a world of difference for that employee who used to be able to comfortably hop on whatever train was available to get them from close to their home into your office and back again, obviously, at the end of the day. And now all of a sudden they find not only are they not going into this large city, they're going all the way around it to the other side. And all the way around it may not have the public transit. All the way around it may require driving in a car. All the way around it might require now getting up at 6 o'clock in the morning just to be at work at the hour that the person had agreed to. And that, frankly, could be a reason that you, in effect, change that person's job so much that they can say, you let me go, because for practical purposes, I just can't do this anymore. I don't want to drive 1 3/4 hours each way to work, not only doing, what times are they doing it, where are they doing it. The next point is, who is this employee going to report to? What does that mean? Well, if we're talking about a travel agency in Regina, and there's one person in it, and you're the boss, and you're the owner, and you're the only person there, then obviously they're going to report to you. If we're talking about a slightly larger operation, then it may well be that you will have 3 or 4 people reporting to this person, 3 or 4 people reporting to this person, and you should make that clear. Why should you make it clear? Because then it's what that person says that's relevant. Relevant to whether they can take some vacation. It's relevant to whether they can take the day off. It's relevant for a number of reasons, and as long as it's clear who that discussion is with, everything will be fine. A probationary period. Lots of people find probationary periods upsetting or bothersome or offensive. Once again, I would say to you whether or not the person knows how to do the work. Chances are they do know how to do the work. You've looked at some references, you've looked at a curriculum vitae, and you've decided that this person knows what they're doing. But it's equally important that they're going to fit in, more so in a smaller operation than a big one. And if you think you can sort that all out in a month, that's fine. But there's no reason not to have a probationary period of a few months. And if you're going to have a probationary period of a few months, then what you should also have in there is the ability for either the employer or the employee to cancel or to end the contract with a certain amount of notice. And if you're talking about 3 or 4 months of probationary period, then I would suggest put in something like a week. Not just a week for the employer to end the employee's relationship, but also a week for the employee to say, this isn't working, time for me to get out of here. Next point, the length of the contract. Sounds a little obvious, as perhaps some of these things all do, but this is very important. And if you're going to have a length to the contract, then put in the start date, put in the end date, and everybody knows when it ends. Everybody knows on what basis it ends, and everybody knows that as of July the 30th, September the 30th, or whenever, the contract's over, no one's expected to come to work, no one's expected to make any payments. If you're not going to have a length of time for the contract to last, then the notice periods, the time during which you can advise someone that you don't want to be in the contract anymore, becomes a lot more important. Also, though, if you think that you can get around having long-term employees simply by having them sign 6-month or 12-month contracts, you may need to say necessarily, if you don't do it very, very clearly, that you might not have problems down the road. We have a question. which you can all see and I just noticed. How long is a typical probationary period? I've heard a probationary period lasting as long as 8 months. Is that typical? I don't think there's a typical one, Georgina, but what I would say is it's the nature of the job that will determine whether it's a good idea. If this person, for example, has got to fit in with more people and more things, then you're going to want to have a longer probationary period because it's as much about the human interaction, probably mostly about the human interaction, as it is about whether the technology or the tools of the trade are something this person can get along with. So 8 months, is it typical? I wouldn't say so, but 3 to 6 months is frequent, and that would include, going outside of the travel arena for a moment, bank employees will often get a 3 to 6 month period, and other companies like that. Can you speak louder? Okay. How is this, Jane? Am I speaking loud enough now? Let me know. Don't leave me hanging. Yes, lovely. Happy to speak louder. Let me know again if it gets quiet. David too. Well, speak up, David. Don't hold back. All right. I shall speak this loud. So, where were we? Probationary periods, length of the contract. Excuse me. Now let's talk about the different types of compensation. And it's important to use words here that we can all understand and use consistently. Compensation deals with all of the aspects of the way in which the employee is compensated by the employer. What's the basic one? Well, the basic one is the salary or the wage. You want to set in there, what is the amount of the salary? If this is the sort of person that's going to work on a bonus or commission structure, then you need to understand exactly how this bonus is earned. And if it really isn't a bonus, meaning it's just an extra $1,000 or $500 that isn't going to be earned from a pool, that isn't coming from profit, etc., etc., then frankly, bonus may not even be the best word to use. What you've got to make clear is how is the person going to earn it? Do they just have to be there on X date, or are they going to do something extra, or is the company going to do something extra in order to make sure that this is earned by them? That's very important. You don't want to get to a fight about it. You also want to make sure when the entitlement to that bonus ends. Now this becomes a very big issue when you're dealing mostly with public companies and there are shares, and whether those shares are vested or not. Because if, for example, someone works for a company, let's say for a decade, and they are obliged then to be given notice, and that notice could be somewhere between 9 and 12 months, if that notice includes the time when all these other benefits, in this case vesting of shares, takes place, then they'd be entitled to get them, unless there was something to prevent them in that. You're talking about someone who's going to earn a bonus, and let's assume it's a year-end bonus, and let's assume it is calculated from profit, then divided amongst the employees. You need to have something in this contract that says, and if you are not an employee, when the bonus is, choose your word, calculated or paid, that needs to be really clear, or you will get into a fight about that. Similarly, with commissions, how is it earned? When is it paid? How does your entitlement to it come about? And we'll talk about that in some examples that I have in the context of the end of the relationship, the firing. But it's very important that you understand, especially with travel people working so far into the future, for example, on the commission setting up, if they're setting up the hotels or brochures, if they are selling so far into the future, we all know they've done the work for next year already. We will assume they're going to be around next year when the payment comes in. What if they're not? You need to be very clear about that. Other forms of compensation. There are other kinds of compensation you've heard of, getting the cell phone or some payment towards the cell phone, the car, the gym membership. Any of those all fall within compensation. And you need to be clear what those amounts are, how it is they are paid, etc., etc. Next, vacation. Let's be clear on vacation, and depending on the jurisdiction that you are listening from today, there will be different requirements in terms of vacation. Everybody in this part of the world, in Ontario, always talks about paid vacation. It's not quite that simple when you look at the act that governs all of this, but make it clear in the contract. Then it doesn't matter. You get to take X weeks off and we'll keep paying you. That should be clear. Everybody understands. Same thing with sick days. Same thing with any other kind of day where a person comes to work and they are or are not being paid. You need to set that out. If you're going to review this person's performance, tell them. Put it in the contract. If you're an employee, you want to know you're going to receive a review. Many, many, many times we will have people approach us and you look at the contract and it says annual review, and the employee will say, well, I haven't had one of those for 6 years, and now all of a sudden they're trying to tell me that I've got a bad review and that's why they want to let me go. Well, that's going to look a little ridiculous, to say the least, if you haven't even bothered to carry it out. Also, make it clear that just because you're conducting a review of the person's performance doesn't mean to say an automatic increase in basic salary or anything else happens. Just because I'm reviewing your performance, just because my performance is being reviewed, that doesn't guarantee me a bump in my income in whatever form. Expenses, if this person is going to be in a position to incur expenses, which are really expenses of the business, then let's make it clear. If there's a form, tell them there's a form. Attach the form to the contract and say, here's the form you need to use. Don't just give me a fistful of receipts. Don't just say, oh, I bought this, would you please give me 20 bucks? Don't do that. Here's the form, make it easy. Why? Once again, you're going to have the employee work for someone for 7, 8, 10 years who says, well, I've been handing out this sort of money all this time, I put the latest one in, it's now $700, and guess what? They say they don't want to pay me. Well, did you use the form? No. Have you ever used the form? Well, there was no form. You're just making your lives more difficult again. Benefit plans. If you're going to have a benefit plan, and by benefit plan, most of the time what we mean is medical and dental coverage. Sometimes it will include short and long-term disability. It depends, and typically, almost always in fact, these plans come from third-party insurers. They're not from the to give them X. And there are all sorts of theories around this. If you provide for your employees 100% coverage, they will abuse it. If you make them pay, they won't, etc., etc. But one important point to note is if you're going to put the benefits in place, if you're going to have disability benefits, meaning can't come to work and so let's get paid, check with accounting folks, but typically would always want to ensure those funds, they will come to you as tax-paid dollars as opposed to money on which you then have to pay income tax the following year. Let's get into some of the meaty, interesting points. Confidential information. Everybody wants to put a confidential information clause in their contracts. Everybody wants it to be at least a page long. And frankly, half the time, if not more, it's a waste of space. Why is it a waste of space? Well, because if the person really isn't going to see anything that's confidential, what's the point of suggesting that they've breached some confidentiality obligation by checking into it? If you've got something that's confidential, if you've got a way of doing business, if you've got pricing models, etc., etc., then maybe you've got something that's confidential. If you do, you'll have a clause in there. Typically, those clauses say, well, enforceable, but, for example, when you take into your possession, in an agency or any other operation, although you don't, ironically, have an obligation to look after your own employees' private information, you do have an obligation, I'm sure you're all aware, to make sure that you look after that client's private information. And what you're going to have to do if you have a problem after the employee leaves is you're going to have to take steps to chase after that person to make sure they haven't got any private information or confidential information, because you're the one that has the obligation to protect it. That's a circumstance in which you will want to have the confidential provisions in there to look after that, not because you think you've got some great business method which everyone and their dog is already using, but because that won't help you. Inventions or work product. Let's just see if Shelley has a question about confidentiality. Is there a template? No, I couldn't tell you that I know of a template, Shelley, although I bet you $5 that if you did a Google search on the internet, you'd find all sorts of confidentiality provisions, and the only challenge you'd have then is making sure that it makes sense for this particular employee. I've seen circumstances where someone signs a contract, it's the contract that's always used in this company for X kind of employee. Turns out they didn't really think about or turn their attention to, or dare I say, consult their favorite lawyer, about the type of work this new person was doing. And so now we've got a contract that doesn't really address the type of job that person was doing. The confidentiality clause doesn't make any sense, etc., etc. So yes, I'm sure you could find one with a Google search. Run it now and give it a go. But do be careful to make sure that it makes sense in the context of the relationship that you are entering into. Inventions and what we call work product. What does that mean? It means that if someone's going to work for someone else and they're going to come up with some nifty, arguably discreet way of doing something, you need to be clear on who that belongs to when the relationship ends. While the relationship's going, chances are no one will be upset, but when it ends you need to be clear. And that's important that it be understood in the contract that anything that is developed, anything you come up with whilst you're working here is going to belong to the person paying the freight. Let's talk about non-solicitation and non-competition clauses together. And let me make a bold step. Have them not compete with you. Good luck trying to enforce it, because we in the snowy white north believe in a free market. The average judge and anyone else you come across is going to feel that way, and they are not going to permit someone to stop someone else earning a living. Bottom line. Chances are you won't need a non-competition clause, though, and the non-solicitation clause is likely sufficient, and judges will say you should have used a non-solicitation clause, not non-competition, because it would have been sufficient. What the non-solicitation clause does do for us is bring up the interesting issue, the age-old issue, the as yet unanswered issue or undecided issue in the travel industry, according to all of us at Heifetz Crozier Law anyway. Who owns the customer? Who owns the client? And I suspect if we had a group of you sitting here as opposed to out there, and please feel free to chime in with your thoughts, most people would say that those customers belong to the individual agent. Why? Because we know from a very human point of view, when they leave somewhere, those customers are going to stay with them. And you could argue that that's more so today because of the age of the internet, because then they're very, very loyal customers because they choose not to use the internet or some other means to buy travel. So even more so, they are likely to leave with the individual agent. It's not an answered question. It's not a question you want to be the first person to answer in front of a judge, so let's make it clear. Oh. Sorry, I was just looking at the question. David, you have one or a comment? I'll keep going, and then when it comes up, we can deal with it. How do we deal with it? We can deal with it in temporal terms by saying anybody you had when you got here, they're yours, or they're mine. And we can deal with it in the sense of saying anybody that came to you in this fashion is going to remain in the shop. So if they called in or came to you by some methodology, for example, they follow you on Twitter, they came to you on your Facebook, you'd have some form of recognition that they really were coming for the individual, and that may be a way that you're happy and that the other person is happy with, using to define how it is. Bottom line, put something in the contract, and after you've decided what it will be, track it. Track to make sure that it's clear how the person came. That way, even if you can't agree on, well, who does this person belong to, you're going to go a long way towards resolving that problem, because one or the other is going to be able to say, well, they came here because of this. They came here because they came to my Facebook page. They came here because they called the agency the travel agency telephone number, which is a whatever, 1-800 number. That will at least assist you. Yes, David, you heard of a BC case, and in fact that BC case is the case that I'm going to be talking about in June, very specifically, and you heard of that case. It is a quote-unquote gigantic case, by which I mean I think it's about 100 and something pages long. Is it possible that the sales consultants could find themselves in that position? Absolutely it is. I don't want to get too deeply into that in this time today, not just to compel you to come back and listen to this talking head some more, but because it's a very specific part of a contract, and depending on the facts and the circumstances it could. Let's just put it like this. If you do something silly, and I'm not suggesting this is what happened in the BC case, but if the night before you leave you decide to take paper copies, or you forward to your email, or you do something else silly that takes every single client off the mainframe computer of the employer, are you going to have problems with a judge down the road? Yes, you certainly are. Yes, Shelley, if you hired someone without a contract, can you present a contract to them 2 years later so everything is not just informal but in writing? Yes and no. Why do I say that? You most certainly can present the contract to them, and they're more than likely to sign it if it represents all of the elements that we've been through, and the few that I have left, if it represents them in a way that is factually correct. But for example, and this is something that we see quite a lot of, you hire somebody. You don't, a short letter, there is no written document, or there's a written document but you don't talk about it. And 2, 3, 4, doesn't matter how many years later, you decide, oh my goodness, if I want to let this person go, they've worked for me for 6 years, I'd have to pay them all sorts of money because that's what the lawyer says, so I want to go back to the minimum standard in the province of wherever you are, and I want to say you can only have whatever that minimum standard is, 1 week of notice or 1 week of pay instead of notice in order to get rid of you. And the person would then say, justifiably, well, no, it doesn't work like that. Why? Because you didn't put this prerequisite in the contract. You didn't tell me if I came to work for you, you'd only have to give me 1 week a year in order to break the contract or end the contract. And now you want to change the game because my rights are now larger than 1 week a year for working here, and therefore I'm not going to live with it. So yes, you could put it in writing. Yes, you could get the employee to agree to it. If you want to do that and you think you are doing it in earnest, meaning you really are documenting that which is there, then present it to the employee and say, I'd like to get this clarified. I'd like to make sure we're on the same page. I just listened to this fellow on a webinar and he said we should have written this all down, so I'm just trying to write it down. And if you really are just trying to write it down, then you shouldn't have a problem. So we've talked about this a little bit, but the circumstances in which the contract can be ended, you really, really, really want to have this. Oh, just a second. Thinking of solicitation and confidentiality agreements. I see. So you want to have someone sign a non-solicitation and a confidentiality agreement. Less difficult to implement that because that sort of thing would be implicitly read into most agreements. So I don't know what you would gain from putting it in there, but it should be less difficult to implement an agreement that focuses on or just includes solicitation and confidentiality. Circumstances when the contract can be ended. And you heard me talk a few minutes ago about notice, and that's what this is really all about. What circumstances can occur in order for one party or the other party, and it goes both ways, all of these points go both ways. What circumstances can occur in order for this contract to come to an end? And an obvious one would be, well, the death of the employee. It's at an end then because the person can't do what they're supposed to do anymore and clearly are not going to be paid. So by circumstances that should be included, I mean not just the notice period, but circumstances, excuse me, for example, where you can agree up front, well, if this happens, then I'm not prepared to employ you anymore. And one area where this is very tricky because of the human rights legislation is time away from work. Time away from work for illness is what I mean when I say that. So that if you have someone who is taking a very long time away from work, back before the days or the implementation of the human rights legislation, it was pretty much a mathematical calculation, and that was, if I've got an employee who's worked for me for a year and they've now been off for 3 months, they're not doing what they're supposed to do and I can end this contract. I've got an employee who's worked for me for 27 years and they've now been off for 9 months. That's pretty much acceptable because they've been around for a very, very long time. One of the things that makes that a lot more difficult to deal with now, which is more of a reason to put it in the contract, is that human rights legislation says you cannot do certain things based on certain criteria, and one of those is the health of the person. So it can be very tricky to deal with somebody who says, well, I'm not well, and here's a doctor's note, and I'm still not well, and the doctor says this, and I can't come back. It is difficult. It is difficult for the employee, obviously, because you assume most times they're not well. And it's difficult because of the employer having to make sure that it can do what it needs to do. How do you deal with that? Well, in circumstances where there's a belief that it's a legitimate illness, not so much of a problem in terms of checking to see the validity as it is just looking after the job, but it is an issue when you're dealing with someone that you have reason to believe is not perhaps telling the truth. What do you do with that? Speak up. Oh, I beg your pardon. Speak up. Thank you. Coming loud and clear. It's difficult to deal with that kind of employee. Why? Well, because they're telling you they're okay and they've sent you a note. What can you do? You can do a number of things. You can ask them to go to a doctor that you'd like them to go to. You can draft up a form that you can ask them to take to their doctor to say, well, let me just make sure we've understood all of this. This is the person you're dealing with. This is what they've got. This is what they do. You do know that this is their job, and you're saying they can't do it. Let's have you acknowledge, doctor of the employee's choice, that you know exactly what it is being addressed back here at the office. Once again, want it in there, in the contract, want it agreed to, because then at least people have turned their attention to it. Amount of notice. Well, this is the one that comes up and we'll address in a minute in the firing context, but how much notice does one party or the other have to give in order to simply end the contract? Obviously, if the contract's for a fixed period of time, it's irrelevant. These are for contracts that go on forever and ever until someone chooses to end them. You want to address how much notice has to be given, not just by the employer, but also by the employee, especially if the employee is higher up the scale and more difficult to replace. In reality, in pragmatic terms, chances are it's a lot easier for an employer to find an employee, good or bad market, than it is for an employee to find another employer. But you do still want to address this. You don't want to be left in the lurch, and you want everybody to know how much notice they have to give. A couple of other more legalistic terms. A whole agreement clause. What does that mean? Entire agreement, whole agreement. You want it to be clear. In fairly simple language, there's no other promises being made. We've had a coffee, we've had lunch, we've had dinner, we've wooed this particular person. A lot of stuff has been said. But now it's all written in this agreement. Nothing I said at the coffee, nothing I said at the lunch or the dinner is any longer relevant. There's something in there that says only what's written in this agreement is what counts as far as the relationship that you, employer, and me, employee, have from here on in. And one last observation, you don't have to put something into the contract, especially if the person is working in the same province, in the same part of the province that the employer works out of. But if you're going to have someone start moving around the country and there's a question as to where they work, you might want to put in there a dispute clause that says, first of all, if we have a dispute, you can decide if you want to use mediation and arbitration, but simply it's going to be the courts of this province and it's going to be the law of this province. It doesn't have to be a long clause. It just makes it clear, just because you've hired someone from PEI for a company that's in Alberta doesn't mean to say that the PEI law is going to apply, especially if you've sought some legal advice from the employer. All right. Any other questions? I don't think so. So let's move on to the end of the relationship, the firing part. First point, everybody calls it wrongful dismissal. It's a wrongful dismissal case. He has a wrongful dismissal case. There's a wrongful dismissal case going on. Why is it called wrongful dismissal, or what makes it a wrongful dismissal? The only thing that makes it a wrongful dismissal is that the person didn't get enough notice or payment instead of notice when they were told the job was over. So it's wholly unacceptable, for example, to pull in someone to, the office and say, I'm awfully sorry, Jane, even though you've worked here for 17 years, we have to let you go today. You certainly feel free to take all the bobbleheads on your desk and don't take anything else. Thanks for coming out. Obviously, that's not enough notice. That would be a wrongful dismissal. It doesn't become a wrongful dismissal because you don't give a reason for the end of the contract. And that applies both ways. You can quit your job, as long as you give the appropriate amount of notice, for whatever reason you like, and you don't have to tell anybody what the reason is. Show up on Monday, the contract says I have to give 2 weeks notice. You can say, I'll be done Friday next. They can ask you, you don't have to say anything else. You still have to keep working because you've given notice and you're supposed to work out the period. They tell you to go home, but you don't have to say why. And in the majority of cases, it won't be a wrongful dismissal because the employer didn't give a reference letter. You don't have to give a reference letter. Should you? If you can, if this is someone that you can still trust, then absolutely give them a reference letter. Can it be larger or smaller? Can it have more or less detail? Can it contain more or less praise? Yes, of course it can. And if it is the employer that has decided to let the employee go, especially, for example, in circumstances of a reorganization or closing of a particular office, then most definitely you would want to get this employee a reference letter because you want to help them find another job. And the employee clearly doesn't want to have a huge gap in his or her record, so give them a reference letter. So that's wrongful, or what makes it wrongful. But what about this other word that's always flying around, cause? What about cause? Well, what is cause? Let me give you my definition. My definition of cause is a sufficient reason to fire someone right there on the spot. Don't give them notice, don't give them money, fire them now. Just from my tone, you can tell that's a pretty dramatic thing to do, and I can tell you it is a very dramatic thing to do, quite apart from all the effect it has on the person, depending on how much time they've worked for you, but legally it has massive ramifications as well. What's sufficient? Very little that you can come up with today other than very dramatic examples like theft, physical abuse, is going to be sufficient to say this is cause. David, leave the office now. Your job is over. Don't pass go. Go straight to jail. Very, very little that will happen in the context of an employment relationship will be considered X months or years down the road as sufficient cause to fire someone. Many people will come to me and say, well, we've given all these warnings. That's great. Show them to me. Oh, well, we just talked to him about them. Oh, not so great. Well, there were two people in the room. Okay, so get me their recollection. Obviously, that's going to be difficult to prove what was said, and there's going to be a difference of opinion. What about written warnings? Well, great. Show me the file. Show me all these memos you've given this woman for the last 16 months. The difficulty with written warnings is that the written warning has to do certain things. What it has to do is to say, look, Peter, this is what your job is. This is how you're not doing it. This is how you have to correct it, and I'm going to give you X months. If you don't correct it within that period, then this is what's going to happen. Either you will be put back on probation, you will be let go, whatever it is. You need to give somebody a benchmark, and it's going to have to be judged by a third party, firstly by your legal counsel and subsequently by a judge, to be reasonable. You can't just say, Dave, you're doing a bad job, shape up, because Dave has no way of telling why he's doing a bad job or how he can shape up. Suffice it to say, let's put a bottom line, very unlikely that someone with, quote, poor performance is going to be someone who has done something or is in a position where they can be fired for cause and that be successful. Let's talk about a couple of other things in the context of firing, and that's the word severance and the word notice. Severance is a term of art in the Ontario legislation, which I can sit here and tell you very clearly thanks to my colleague Michael Tomasini having made sure that that is the only place it's used technically. It's not a word used technically or legally across the remainder of the country, but it is a word that people throw around. They use severance, they use notice, they use severance package, they use how much notice did you get, interchangeably. And just be careful, they're not always interchangeable. And they will be calculated based on what the individual law of your particular province says. X number of weeks provided for each, or one or the other, or just a notice, depending on the number of years worked. Another important issue in the context of the... Am I speaking too quietly? No? There we go. Firing is caused due to number of performance units in 16 months. No. Thank you, David, for asking that question. No, I didn't mean to suggest that 16 months is a normal period of time. What I'm... no, you're going to know... Well, let's back up for a minute. What I'm addressing here is what period of time, along with the benchmark that you give to this person, what period of time is required in order for them to, quote, shape up. That's going to be very individualistic in the circumstances, A, of the operation that you're working in and the type of work the employee does. So you may say, look, you've worked here, Tim, for the last 2.5 years. We know we've spoken to you about this. We know you've come to retreats. We've given you a chance. Now we're going to give you a formal chance. And here's what we say. we say that after 2.5 years you should know how to do the following 7 tasks. You don't appear to know that. You've got the next 3 months, 2 months, 1 month, you'll decide what's reasonable. The next month to learn how to do that, we're happy to help you. We're happy to support you. These 3 employees, they're your go-to people. Your boss is your go-to person. You've got to get this sorted out in the next month. If when we meet again in the next month it's still a problem, then you're either going to go on probation, and you'll be on probation for 2-3 months to see if you can stay, or frankly, we may just be letting you go. It will depend how dramatic. So 16 months is not a non-performance measure. That was just a number that came to me when I was talking. Salita, you mentioned you don't have to give a cause for dismissal. You have explained. Do you have to explain it later on if they sue you for wrongful dismissal? No. When I say you don't have to give a cause, maybe we shouldn't use that word. You don't have to give a reason why you let someone go if you're not letting them go for cause. If you're letting the person go for cause, then you should describe it. Dear Mr. So-and-so, as you know, last Friday it was discovered that you have, in the words of Johnny Cash, removed an entire motor vehicle from this factory over the last 6 years, one piece at a time. You've stolen this. It's only come to our attention now. We brought this to your attention. You had nothing useful to say. You're fired. That's the cause for you being fired. Not only are you fired, but you're leaving tonight. Not only are you leaving tonight, we're not paying you past today, and we're not doing anything else. So later on, and this is why you have to make this decision when the issue comes up, if you decide that you want to let go a particular employee, one of the things you may do is say, well, do we have a cause to let this employee go? Chances are, as I said a few minutes ago, you won't. You'll come to me and say, we've got this, and he did this, and he did this, etc., 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 and we think it's cause. And I bet you 99 times out of 100 I will say, no. You just want to let this person go. So now we need to decide how much notice they need, and you can give them notice and they have to stay and work, or how much you want to pay them if you feel they have to be thrown out of the office right now. Can you extend someone's probation if you don't have confidence that they are going to fit in the office? How do you explain it to them? I think you'd have a difficult time extending someone's probation, because if you've come to the conclusion they don't fit in, that was the point of having the probationary period. They've got to the end of it. They don't fit in. It's all over. It's time to let them go. It's time to make clear that at the end of the probationary period, or on 1 week's notice, as I suggested earlier, this relationship is over. So compensation is a word I mentioned earlier on, and it's very, very important to ensure that you set out in these employment contracts not only what the compensation is, but what the compensation will be in circumstances where the relationship is ended. Why? Here's why. Most importantly, in the world of commissions or bonuses. Let's take an example. You have someone, they've worked for you for 15 years. There is no cause, if they haven't stolen anything, if they haven't committed a terrible crime on the premises, and I'm exaggerating a little, chances are they are not going to be let go for cause. They are going to be let go because you've decided you don't want them around anymore, for whatever reason. The difficulty will be is if they are a commission person, or they get commission as part of their compensation, and you haven't set out in the contract that in order to receive the commission, for example, you have to be in the employment of this company, then you're going to have problems. One of them is a problem with relationship. Sorry, I think I just muted the voice there. Hopefully everyone can hear me again now. I touched this. You're going to have problems. You're going to have problems with the employee that you let go. Why? Because that person who's worked for you for 15 years is going to say, well, even if I stay and work for my 15 months, 16 months, 13 months, whatever period of notice you give me, when I get to the end of that period, I will have earned another X amount of dollars of commission, even though it won't be payable to me at the end of that period when I stay and work for you. I will still have earned it. So I'll now leave. I will expect you to pay me that commission for the following 6 to 12 months, and you'll say, gosh, as the employer, how am I going to do that? Because the person I bring in to replace the person I let go, I will not be able to pay because I'll be giving it to the other employee. What does that mean? It means that you make it real clear. And one way that makes it extremely clear in the contract is, if you, employee, or more importantly, us, employer, end this employment agreement, the only numbers from your compensation that are included in the amount of money we have to pay you if we pay you instead of giving you notice, it's simple. We'll have to get the employee to agree to it, but at least it's simple to determine when this falls apart. How are we doing? All right, a few minutes. Let's just touch briefly on investigations. What does that mean? Well, you're sitting at your desk happily counting all of the wonderful sales that came in for the first quarter, and you hear that there's a problem, and somebody has done something to somebody else in the operation, or somebody appears to have caused harm to the operation, and you've now got to decide, are we going to let this person go? Fair enough. What you want to do, however, and if you're the employee, you want to ensure this happens, is you want to hear both sides. In the most fundamental terms, you want to make sure that this is fair. You want to make sure that you hear from the person who says, well, I was sitting next to him and he started to do all sorts of crazy things on his computer. Clearly he was setting out to try and down the internal network, and you better look into this because I think he's dangerous and you should fire him. Fair enough, this has happened. There is some damage. You found the damage and you've got a problem with your network. But just listening to the fellow sitting next to him, chances are, is not going to be sufficient. There may be other people around. You need to listen to them as well. When you're listening to them, you need to take notes. You need to make sure what it is that they said so that you can keep it for later on. If in my example of one person damaging a computer, you sit there and think, wow, I have no way of knowing. I don't know enough about computers. And I can't exactly rely on the fellow sitting next to him because it turns out they've disliked each other since they started here 3 years ago. Then you may need to get some independent, outside your company operations advice. You may not, because you may have an internal tech person, or you may have the ability yourself to say, look, you are a trained travel agent. You've been doing this before computers, you've been doing it with computers, you can't possibly expect me to believe that the keystrokes you made were designed to do anything but bring down this network. What's your explanation? If you don't have that know-how, you may have to go outside and get it from someone else. They're independent, but they also have the knowledge. Another question. And you need to have that information in your possession before you make a decision. And chances are, especially if it's a smaller operation, you will be the boss person, the owner. You will be the person who carries out this investigation. You're not going to go outside and pay thousands of dollars to an independent investigator. But the substantive information, or the information about what it is that happened, could it have been unintentional? Could it have just been a mistake? If you can't make that determination yourself, you better go and get that from someone else. The only other point with respect to investigations, other than simply to say be fair, is that you want to make sure you explain to the person whose job is in jeopardy all of what has been said about him or her, exactly what has been said about him or her, because he or she then needs to be able to tell you what their version of the story is. Don't cross-examine them. Don't ask them all sorts of nasty questions. Ask for an explanation. Open your eyes, open your ears, watch and listen, because you're going to decide, first of all, if there's a dispute about what happened, if someone says it was this and someone says it was that, you've got to decide which it was, and having decided that, whether or not that is sufficient to end the relationship with this person. So, that is all I have left to say. If there are no questions, I believe that means this is over. It has been a pleasure staring at this little black dot in the middle of the screen. I hope you have enjoyed it. Oh, someone's typing. No, someone's not. Nice of you to say that. No, I don't think there's any question. We don't. Oh, turn this off.